Good afternoon, everyone. My name is David Tingstad. I'm the chair of the Business and Real Estate Group here at Beresford booth. I have my law clerk, Drew Tingstad, with me. Drew and I spend a lot of time talking about very exciting subjects like the revised Uniform Limited Liability Company Act and the Washington LLC Act. It's actually interesting as we go through those things. And early on in my career, I have to say, I wondered a lot, what in the world does a Uniform Act have to do with my practice out here on the left coast? And what I've come to learn is actually quite a bit. It actually has quite a bit to do with what we do here. For, 13 or so years, I've had the privilege of being a part of the Washington Partnership Law Committee that undertakes, among other things, revisions to Washington's Limited Liability Company Act. It's an interesting process to go through when you start looking at, what should the statute be. And so certainly the things you do is you go grab resources, look at what other states have done. And the Uniform Law Commission has spent a lot of time, a lot of really smart lawyers spending their time thinking about what the law ought to be. So you look at those things, you look at Delaware, for example, you look at California, you look at New York to see what those more populated states have done. And certainly Delaware is one of the leading business law states in the world, frankly. And so what they have to say is important. And I was struck, and what kind of led to Drew and I putting this presentation together is that in a recent Washington case called Berman v. Tierra, a Washington Court of Appeals said the following: as Washington's act was substantially modeled on the ULCA, and by the way, I'm going to refer to that as ROLCA, just because I've dealt with the Uniform LLC Act for a long time, and there's a number of iterations of this, so I'm going to call it the revised Uniform Limited Liability Company Act. So if I say ROLCA, that's what we're talking about. It was last revised in 2013. Anyway, let me get back to the slide here. As Washington's act was substantially modeled on ROLCA, we may look to the ULCA to assist in our interpretation, close quote. I was shocked when I saw that because, look, the legislature adopted the act, I get it, but our committee drafted it. And that's just not true. We actually started looking at ROLCA, decided that couldn't work in Washington, we as a committee. And so while we consulted it for what we did, we didn't model our act on ROLCA. And then going a step further here, just from looking at this, what the court cited to is Drac versus Dutray, that's a 2007 case. And Washington adopted our new act in 2016. So how the court can be using a 2007 case to say what happened in 2016 is beyond me. Nevertheless, that's where we are. And so in looking at that, I just thought, it's a good time to maybe do a little compare and contrast. I've written a recent blog post on this different. There'll be more to that series. Drew and I will be working on that over the next month or so. And so we thought what we thought we would do, given what the Berman case has what the court in the Berman case has said, is really kind of try to draw out some of the distinctions. And as we draw out some of those distinctions, one, I think it will become apparent that we didn't model Washington's act on ROLCA. And I think the importance of that for Washington practitioners and for folks in Washington is that you don't get to go look at both ROLCA and ROLCA states as authority for something that's happened in Washington, just given the dearth of case law about Washington LLCs. And that's really sort of my cautionary tale here. And now that there's court authority out there, it really makes me nervous because it's just not true. So what Drew and I are going to start doing here we're gonna talk about a few of the differences from a structural standpoint, from a definitional standpoint, and then we'll talk about some of the more meatier sort of provisional provisions where you can start to see some of these distinctions. And I think as we see these distinctions, it will help us understand our own Washington LLC Act a little bit better. So Drew, I'm going to go to the next slide with any help, and there it is. You want to address what, in your view, some of the organizational differences between our act, and let's just call it that, the act, and ROLCA. If you want to call it ROLCA, you're welcome to that. I know what you mean. I'll turn it over to you.
Yeah, well, just kind of going back to that Berman case, they said, that the act was substantially modeled on ROLCA. And I think that it's important because these differences that we're pointing out here are no small matter, particularly once we get into the provisional differences. We're not splitting hairs when these are differences. There are substantive differences going on. So starting with the organizational differences, there are actually quite a few of them. And importantly, as you said, the Act came out in 2016 and ROLCA was last revised in 2013. So I think there's a clear indication that that the drafters of the Act had an intent or wanted to have a different perspective in publishing the Act. So here we have ROLCA that we can lean on, but this came on after, and we have in the Act some actual differences just coming to the organization of it. So as we see on the slide, the Act has 13 articles, whereas ROLCA has 11. And the most kind of jarring difference organizationally is that the Act has an entire article regarding dissenters' rights when ROLCA has no mention of it. And that really jumped out at me when I was reviewing the two, because dissenters' rights are a big thing in Washington. And in terms of the other...
Drew, I'm going to rudely interrupt you here for a second, just to highlight what you just said, because it's really absolutely critical. The point that you made at the beginning, saying we're not splitting hairs here, right? These are major differences, and a major difference is from a policy standpoint. If you think about this, that the drafters of ROLCA said we are not going to give members the right to dissent from certain actions, and those actions are typically things like mergers and conversions. Okay, so major fundamental changes. And in Washington, a member has the right to dissent from a merger or a conversion. And when they do that, they also get what are called statutory appraisal rights. And so that basically means that the LLC has to give a number, and then the other member has to give a number, and a court's going to choose how much has to be paid for that interest. So I don't want to get caught up in exactly what dissenters' rights are, Drew, except to highlight this point that the entire filter of what ROLCA is doing has made a policy choice. And so what all the drafters did, they said, look, our decisions in these other parts of the Act governing things like statutory apparent authority.
Did we lose him? Did he freeze? I'm not sure if it's me that's lost it or if he did. Well, I can just keep it pushing if we want to get the technical issues figured out on his end. He's making a good point here. Essentially, what's important is that the dissenters' rights are a big deal in Washington and everything that comes along with that. Now, ROLCA doesn't mention it, and there's different cases discussing dissenters' rights within ROLCA in the different jurisdictions. But importantly, they don't mention it in ROLCA, and the drafters of the Act specifically included dissenters' rights. It's just a big difference, organizational difference between the Act and ROLCA. Among others, in terms of organization, ROLCA calls things differently than the Act does. While the Act has an article for members. OLCA splits its article about members in relation of members and managers to persons dealing with the LLC, and relations of members to each other and to the LLC in two separate acts, or articles rather, in OLCA. And then the Act has an article for management and managers, and OLCA deals with that in a different article titled Relation of Members and Managers to Persons Dealing with the LLC. So there are, and I can keep on going through, and they just call things differently, which is kind of a decent segue into the definitional differences that we have between the Act and between ROLCA, because the Act defines terms differently than we're going to see the terms defined in OLCA. And some of which, are basic, and we see these, just jurisdictional differences generally, where we have certificates of formation versus certificates of organization, or you have the LLC agreement versus the operating agreement, just terms that we're going to call things different. But it's important because ROLCA was last revised in 2013 and the Act came out in 2016. So these are intentional differences that the drafters of the Act made. While they had ROLCA to lean on, they specifically chose not to follow that. And I think that that's just important to realize that these are not the same thing. The Act and ROLCA are not the same thing. The drafters of the Act intentionally chose to shy away from defining terms similar to ROLCA. Some terms are the same, but I digress. And then there are some terms that are completely omitted from OLCA that are defined in the Act, and some terms in OLCA that are defined and not in the Act, kind of the vice versa of those two. Terms like agreed value, execute, foreign professional limited liability company. The Act includes definitions from that, whereas OLCA omits any definition of those terms. And on the flip side of that coin, you have the Act omitting definitions that are included in OLCA, such as contribution, debtor in bankruptcy, jurisdiction of formation. And while those might be splitting hair differences, we're going to get them back. Maybe. Almost. I hear you.
Well, sorry about that. Little technical difficulties always makes life a little bit more interesting. So, Drew, I interrupted you, and I was on a roll for a minute. I don't know how much you heard about talking about. So let me get this back up on the screen here. Okay, and I'm going to share.
Well, you were getting on your soapbox about dissenters' rights,
yes.
and cut off a little bit there, and I just kind of kept it going and started talking about the general organizational differences. While we have an omission of dissenters' rights as a section in the Act, there are other sections in the Act that talk about certain things and give an entire article on those, whereas in OLCA, they either are mentioned a little bit or not given their own articles, or they're split into different articles. And there's just a different approach to defining certain things and legislating certain things throughout OLCA than there is in the Act. I also went into a little bit of the definitional differences.
Right. Okay.
And kind of was chipping away there, and then we got you back.
Well, very good. So maybe if it's a good time, I'll go into some of these provisional differences since you.
By all means.
All right. Well, and feel free to interrupt me. I've rudely interrupted you. You feel free to do the same. So big one here right out of the gate in ROLCA. There's no, and I see I have a typo here, statutory apparent authority. Don't look at my misspellings. ROLCA has no statutory apparent authority. So what that means is in Washington under the Act, we have a specific statute that says members in a member managed LLC and managers in a manager managed LLC are agents of the company. Okay, so think about that for a second. If I'm a member of an LLC, I have the ability then to bind the company because I'm an agent of that company. All right. Where again, the drafters of ROLCA have made a completely different fundamental policy choice to say, no. In ROLCA, the members aren't agents, don't have the authority. So I was talking, Drew, probably when I was frozen out, I was talking about with dissenters' rights of how everything that the drafters of ROLCA did are seen through a lens of we're not going to give dissenters' rights and we're not going to give statutory appraisal rights, which led them to certain policy decisions. Okay. Well, another one of those lenses is this lack of statutory apparent authority is a major change in ROLCA. Okay. And so we can talk about whether that's a good policy choice or a bad one, which isn't the point of this webinar. But the point of this webinar is to say that's a major difference to be able to then, if you're going to go grab, for example, some cases that are decided under ROLCA when a member or manager does not have statutory authority and try to take that and apply that to a Washington LLC that where we do have statutory apparent authority. And this is why I'm concerned about what the court did in Berman, because it's like, wait a minute, those are really, really different. You don't get to talk about those things in that way. So in other words, you should be looking at a state that if you're trying to compare, case law in other places, you should look at states that have statutory apparent authority if you are going to compare what's going on in Washington with another place. So that's a major policy difference that I think we've got to be very careful about as we look in ROLCA. Next thing, ROLCA expressly allows pre-formation agreements, and so I find that's really interesting when you think about it. That just from a metaphysical standpoint, from a policy standpoint, the drafters of ROLCA would say, you know what? Sorry, I got to get these things off my screen that keep popping up. When you make a policy choice to allow pre-formation agreements, you're allowing something that doesn't exist yet. So I'm going to form an LLC next week that doesn't exist today, but I'm going to allow it to enter into a contract today. That's kind of interesting, just sort of philosophically, if that can actually happen. And it raises the question, I suppose, in Washington, are pre-formation agreements allowed? Our act says nothing about it. We certainly have, I think from a different perspective, we can talk about promoters of LLCs that, hey, I'm going to go enter into a purchase and sale agreement for an LLC to be formed. Well, that might result in personal liability of that person who decided to form, or maybe they didn't. But that's different than whether the entity itself can enter into a contract without it being formed. But yet, nevertheless, ROLCA says you can do that.
And just real quick, if I can hop in, it's interesting in ROLCA how they treat pre-formation agreements, because in ROLCA, there's no writing formality in these things. And so whether or not we're going to have a pre-formation agreement, it causes a bunch of issues and questions as to what is the pre-formation agreement? When does the pre-formation agreement become our operating agreement? What are the terms of our operating agreement? And so it just kind of throws this major question mark into a lot of these cases. And that's an issue with ROLCA that, while not discussed in the Act, there's a little more wiggle room in the Act to decide these things through case law. So
yeah, no, I think that's right. It's a great point. I mean, think about that, Drew. You and I entered into an LLC agreement for an LLC that doesn't exist. What do we got?
Mm-hmm.
I suppose you and I could enter into a contract that says we're going to form something. Okay. much like we're going to go enter into a purchase and sale agreement, but there's nothing special about an LLC that should or shouldn't be able to do that. But nevertheless, to have an LLC agreement governing and incorporating all of this statutory stuff that we're talking about for an entity that doesn't exist, to me, I don't know, maybe I'm just not, I don't think metaphysically enough, but that makes my head hurt. It really does. And so that, and not only does the Uniform Law Commission allow for pre-formation LLC agreements, they also allow for what's called shelf registration, which means you go out and you form an LLC with no members. And this sits out there. Okay, I formed this LLC even though it doesn't have any members. Okay, I don't know what to do with that. And yet it's a real eventually members will be admitted, and then it becomes like in Washington, you have to have members to have an LLC. Okay. Well, apparently you don't under ROLCA. And that's how shelf registration works, which is kind of again a make my head hurt sort of thing. Another provisional difference: ROLCA authorizes special litigation committees expressly. And again, when you start thinking about these policy differences between ROLCA and the Act, it's why you can't just sort of pick and choose. Oh, well, theirs is just like ours, and this is one little. No, there's a lot of major differences, and this is one of them. So Washington, our Act it allows delegation of authority by a manager, for example. Well, does that mean that the manager can delegate to a special litigation committee? Are they authorized in Washington? I don't know. ROLCA says, oh, you can have a special litigation committee, and Druid has a whole section on that, right? And it talks about what the committee can do and all that.
That's right.
Well, not so in Washington. So again, a major policy difference, which may be a reason why dissenters' rights aren't allowed under ROLCA, but they are under the Act. I don't know, but that could be a reason. And then the next thing, and by the way, these provisional differences, we're just kind of picking and choosing some of the major ones. This is an exhaustive list, but under ROLCA, and there's a whole body of case law out there about protecting minority shareholders, minority members of LLCs, that sort of thing, from oppressive conduct. Okay, and so in the business divorce world, you have situations where the majority exercises its authority to effectively reduce the compensation of or fire a minority member or minority shareholder. And so in several states, that is expressly a ground for judicial dissolution of the entity. In Washington, our Act is very simple when it comes for judicial dissolution. Judicial dissolution happens when a member applies to the court for the court to say it is no longer reasonably practicable to do business in accordance with the existing LLC agreement. And then it says, or other circumstances make dissolution equitable. Don't really know all of the recognized grounds in equity that may be available for that sort of other part of judicial dissolution in Washington. Could it be, the oppression that we're talking about here? Sure, I suppose so. But doesn't have to be. And so again, another sort of major difference. I mean, judicial dissolution is absolutely taking a sledgehammer, to a problem with the LLC. So when should it be allowed? Our cases have been really clear. It should be really rare when that happens because it is such a drastic remedy. So I don't know what the oppressive conduct grounds for judicial dissolution adds to Washington, but if we had it here, but we don't. So a major difference from a provisional standpoint. And so what our hope here in making this presentation is that as we go, as you read, and I'll just flip back here to the Berman case, as you look at that, again, I just don't think that you can conclude that our act was substantially modeled on Roca, given what we've talked about. And there's a lot more. And again, I've got a series of blog postings that will be coming out on Washington Business Law blog.com, which I'll refer you to. And so, we do a lot of work in this area here at Beresford Booth of all things sort of dealing with LLCs. Very much a developing area of law, and it's really a lot of fun. And so if you'd like to talk to people like Drew and me who just get really excited about these issues, and we do, we love what we do, and it's a lot of fun. And Drew, I'm gonna take the last word, but I'm gonna give you the chance for the second to last word. Anything you want to add here before we let the folks go about their day?
Well, no, like you said, I mean, we just kind of picked and chose some of the major differences, but I mean, by no means is this a definitive list. I mean, there are other differences regarding fiduciary duties, and how to disclaim them, and all sorts of things. And it's the least of which clear that no, the act is not substantially modeled on Roca. The opportunity was there, but the drafters of the act made clear decisions to veer away from following Roca. And I like you, I find this stuff really interesting, so much so that I am currently writing a paper on that at law school with one of my professors. So we're just kind of scratching the surface of the difference. Is that a tease,
Drew, for what's coming in the future? People can wait somewhere.
Shameless plug, I say. Shameless plug. I'm sure everybody is dying to read more about the differences between Roca and the Act, but dang it, it's coming.
That's right. Well, very cool stuff, and I'll tell you, I'm interested to read it. And I will just to echo what Drew has said. Not only am I saying this, but in 2016, when the Act came out, the chairs of our committee, Brian Todd and Doug Beatty, wrote some materials, kind of summarizing the Act. The materials are out there, especially saying exactly what we just said here. We did not model the Act on Roca. We didn't do it. So don't take Drew's word for it. Certainly don't take my word for it, but take Doug Beatty and Brian Todd's word for it as well, because we just didn't do it. And there will be more. I'm writing some stuff here too as well that'll hopefully through the Partnership Law Committee will come out here shortly. But anyway, interesting subject, and certainly would recommend everyone take a look at our Washington Business Law blog, because there's more information there and more to come. Thanks, everybody. Appreciate you participating, and our contact information is there on the screen, and look forward to hearing from everyone. Have a great day.